Hi everyone, I am Vishwavardhan. You're watching Learn with Phonology, and in today's video we are going to cover a topic which is very important from your academics point of view, and the topic is talaq under Muslim law. Now I would request you all to just pay a bit more attention so that your understanding is clear. Now before moving on with the video, I have a question for you. Meher or dower, which is a very important concept under Muslim marriage, belongs to whom? Whether it belongs absolutely to the wife, to wife's father, to wife's mother, or partly to wife's parent and partly to the wife. Write down the correct answer below in the comment section and I'll tell you the right answer at the end of this video. So let's start off with the video now. Under Muslim law, divorce can be filed by a husband, by a wife, or they can mutually, through the process of mutual consent, go for divorce. Now divorce are granted mainly through two processes. First one is extrajudicial divorce and the second one is judicial divorce. Extrajudicial divorce are those ways which are given particularly under the Muslim law and they do not involve any element of court. And whereas when we talk about judicial divorce, as the name itself suggests, judicial divorce, here the court is the one that exercises the power of granting divorce to a husband or wife. Now if you look into this chart, we can see here this is the process of extrajudicial divorce. Now under it, by husband, the divorce can be pronounced in two ways. First one is talaqul sunnat, which involves again two elements, which is talaq ahsan and talaq hasan. After that we have talaqul biddat and followed by illa and zihar. Now we move on to the divorce by wife. Now how wife can give divorce? There are again two ways given here. First one is talaqul tafweez and the second one is liyan. And after that we have mutual consent, divorce by mutual consent, which is khulla and mubarat are the two ways for mutual consent of divorce. Now if you move on to the next one here, we have judicial divorce. Judicial divorce involves the act which is called Dissolution of Muslim Marriage Act of 1939. Under it, a husband, a wife, or through mutual consent, they can take the divorce, and under it, section 2 specifically contains the ground for divorce. So let's begin with the first form of talaq that a husband can give, and which is talaqul sunnat. So here sunnat means the ways and the practices of Prophet Muhammad, and this in a simple language we can call the traditional way. So this talaqul sunnat again is divided into two forms of talaq, which is talaq ahsan and talaq hasan. So here talaq ahsan basically is considered to be the best form of talaq, and what happens under this is the husband makes a single pronouncement of divorce, and this he does during the period of tuhar. Now tuhar is a time period when the woman is not menstruating, and once the divorce has been pronounced by the husband, a period of 90 days begins from this point, and during these 90 days the husband and wife should not indulge into sexual intercourse, and if they do so then the divorce will be irrevocable. That means that cannot be cancelled. But if this condition is not fulfilled, then the divorce will become revocable divorce. That means that can be cancelled. Now this 90 days period is very important because during this time, if the husband and wife thinks that they want to continue their life together, they can do so and revoke their divorce. And if during this time they want to use any other method for their reconciliation, that is arbitration, mediation or conciliation, they can do so and they can continue their life from there. And now let's move to talaq hasan. Talaq hasan is considered to be a good form of talaq. Like talaq hasan was the best form, talaq hasan is a good form of talaq. So what happens under this is the husband makes three pronouncements. Now this is not that triple talaq case, and I'll tell you how. The pronouncements are made in three successive tuhars. So the first pronouncement is made in the first tuhar, and that tuhar is a period when the woman is not menstruating, and then a few days of wait when the woman is menstruating, and then the second pronouncement is made in second tuhar, and then the third pronouncement made in third tuhar. So this is how this talaq hasan works. So during this time, again the important condition is the husband and wife should not indulge into sexual intercourse. Now here one more interesting thing to note is, suppose if the husband has made the first and the second pronouncement, and if he thinks now that he wants to live his life with his wife, then he can continue his marriage from that point on. But if the three pronouncements have been made, then in that case that marriage will be dissolved and the husband and wife will get separated. And the next form that we are looking is the talaq-e-biddat. Now this is the controversial triple talaq. What happened under this was, if the husband would make talaq pronouncement 3 times, the marriage would get dissolved. Now there was no system like what we have seen under talaq-e-hasan, that the pronouncement should be made in 3 successive tugas. At any time, if the husband makes 3 pronouncement of talaq, the marriage would dissolve. Now this was declared unconstitutional in the Saira Bano versus Union of India case of 2017, and this is not in practice now. So let's now consider what is the difference between triple talaq and talaq-e-hasan. So what happened under talaq-e-hasan is, under talaq-e-hasan there were 3 pronouncement of talaq made in 3 successive tugas, whereas under triple talaq the 3 pronouncement could be made any time. Apart from the ways that we have seen for talaq by husband, there are 2 additional grounds which are given. Now the first one is illa. What happens under illa is the husband takes a pledge or an oath that he will not be involved in sexual intercourse with his wife. And if he does so for a period of 4 months, then the right is automatically given to the wife, wherein she can approach the court to get a decree of divorce, or even she can ask for restitution of conjugal rights with her husband. Now after it, we have the process of zihar. What happens under zihar is, if the husband compares his wife to a woman coming under prohibited degree of relationship, like he compares his wife to his mother or his sister, then the wife has the right to pronounce divorce. Now if this happens, then the husband and wife cannot live together for 4 months, and after 4 months zihar is said to be completed and the marriage gets dissolved. So up till now we have seen how a husband can pronounce talaq, but do women also have such right? So see, under Muslim law, women can pronounce talaq through 2 ways. Under it, the first one is talaq-e-tafweez. Now under talaq-e-tafweez, what happens is, the power to pronounce talaq of the husband, he delegates that power to his wife. Now this transfer can be absolute transfer, meaning that the wife will have the absolute power to pronounce the talaq, or it can be conditional. So suppose if certain conditions get fulfilled, or if certain situation happens, then only in that case the wife will have the power to pronounce the talaq. Now when this happens, the husband is delegating his power to his wife, then the reason for such delegation should also be given. Now after this, we have another way, which is the way of li'an. What happens under this is, if the husband is leveling charges of adultery against his wife, then the wife has the power to approach the court and file for the decree of divorce. This is one such way, and if we consider it, there are 2 such ways in which the wife can pronounce the divorce. And now we will look into the ways of mutual consent of divorce, wherein the husband and wife can mutually agree among themselves to take the divorce. So this is governed by the Dissolution of Muslim Marriage Act 1939, and under it 2 ways are described. Among them, first one is the process of khulla. What happens under this is, here the wife offers for divorce to the husband, which has to be accepted by the husband. Now whenever the wife offers for divorce, wife has to pay compensation. Why? This is simply because under Muslim law, the marriage is considered to be a contract, and we know that whenever the contract breaks, a compensation needs to be paid. So here the wife will have to pay from her property. So whatever gift, which is meher or dower, which is given by the husband during the time of marriage to the wife, she has to return it back to the husband as part of compensation. And after this only the process of khulla will be finished. And one more important thing is, the period of iddat is very important here. The period of iddat has to be observed by husband and wife under khulla also. Now from this moving on, we have the second way, which is mubarat. Under mubarat, what happens is, this is a process of mutual consent divorce, wherein husband or wife, among them both can offer for divorce, and whenever this divorce is taken, this is very simple, and the divorce is granted and becomes irrevocable. And now we will move on to look into what are the judicial processes for obtaining divorce. Now, the judicial processes are governed by the Dissolution of Muslim Marriage Act of 1939. Under this act only, there is section number 2, which contains specifically 9 grounds of divorce, basis of which the divorce can be obtained. So under it, the first ground is absence of husband. If the husband is absent or is not heard of for a period of 4 years, then in that case divorce can be obtained by the wife. Then comes second point, which is failure to maintain. If husband without assigning any reason is unable to maintain her wife for 2 years, then in that case also divorce can be sought. Then comes imprisonment. If the husband has been imprisoned for 7 or more years, then in that case divorce can be sought. Then comes failure to perform marital duty. Now if a husband is unable to perform his marital duty straight for 3 years without giving any reason, then that can be made the ground for divorce. After that, fifth point says impotency of husband. That means if the husband is not capable of procreating a child, then in that case also divorce can be sought. Then point number 6 talks about if the husband is suffering from insanity or venereal disease, then because of that divorce can be taken. After that comes repudiation by wife. Now see, if there is a girl who has been married at the age of 15 years by her father or by her guardian, then that girl will reserve the right that once she is of 18 years of age, then she can dissolve her marriage, but provided during this time there should not have been any intercourse between the husband and the wife. Then comes point number 8, which talks about grounds recognized by Mohammedan law. This basically says that any additional grounds which are mentioned under Mohammedan law to get the decree of divorce through judicial process can also be made the ground. Then comes 9th point, which is cruelty by husband. Now cruelty would include physical assault, and also it would include if the husband speaks anything about the character of the wife, giving false statements. Then if the husband asks the wife to commit any immoral act. Then comes if wife is not allowed to practice her religion. And at last we have that if there is more than one wife of the husband, these are additional grounds under cruelty for which divorce can be sought. So the answer to the question that I've asked you in the beginning of this video is option A. It belongs absolutely to the wife. So I hope that you have liked this video and this was helpful for you in understanding what is talaq under Muslim law. So please do not forget to like and share this video and subscribe to our channel of Learn with Phonology, and also you can follow us on our Instagram page at Phonology Legal.